Welcome to the Divorce Whisperer. We're going to do something a little different today. We've had some listeners call in and write in and request that I dedicate one show to giving some legal explanations about the different ways to get divorced. So that's what I'm going to do today. Let me introduce myself. I'm Marta Papa, the Divorce Whisperer. And I'm a divorce lawyer and mediator for about 35 years now. And we have a broadcast on our Facebook page called Ask the Divorce Whisperer live. And we do this on the first and the third Friday of every month. And I usually interview a guest who has something to do with divorce, who has some information about divorce that I think might be helpful to people who are going through a divorce or facing that crisis, or for friends of people that are facing that crisis in their life. So I usually ask them questions, and then the main question I ask them is, if you could only give one piece of advice to a friend going through a divorce, what would that piece of advice be? And then we kind of riff on that, having them explain what that piece of advice is and why they think that's so important. But today, listeners have asked for a show on what are the different ways to get divorced? And so that's what we're going to dedicate today to doing. What are the different ways to get divorced? And so basically, there are 3 different ways to get divorced in Missouri. And actually, this applies to most states. It applies, what I'm saying also applies to Illinois, as well as Missouri. And I'm going to talk about those different ways using the easiest, fastest, and cheapest, telling you about the easiest, fastest, and cheapest way first, and then go down to the slowest, longest, most expensive, really most excruciating way to get divorced. So we're going to start at the top with the easiest, simplest, least expensive way to get divorced, and that's called a non-contested divorce. And that's kind of a poor word to use to describe this kind of divorce, but that is the legalese word that we use to describe this kind of divorce. But I think it's kind of confusing, so let me tell you what it is and what it isn't. So a non-contested divorce sounds like both people want it and nobody's contesting the divorce. That may or may not be true. What it means in legalese is that only one person hires a lawyer and tells that lawyer let's use husband and wife in this situation. It tells that lawyer what husband and wife or the 2 spouses have agreed on in 3 different areas that are the typical things that need to be agreed upon to get a divorce. And you have to agree upon them and tell the judge, this is what we agreed upon to get divorced. And those 3 different things are, 1, how you're going to divide your assets and debts that were acquired during the marriage, right? So 2 spouses have to come up with a way to fairly and equitably divide their assets, all their assets and debts. That's just not the house and not just the cars, but also household goods, pets, furnishings, kitchen stuff, boats, timeshares, bank accounts, CDs, retirement accounts, everything that's considered an asset, and debts, credit card debts, debts owed for school, school loans, debts owed to hospitals or medical bills, or loans from family members, any kind of loan or debt that they owe on. So they have to divide that up. A second thing, if there are children born during this marriage, the couple needs to come up with a parenting plan for how the children move back and forth between mother and father, or spouse A and spouse B. So a timed parenting plan, a decision-making plan, who's going to make decisions about the children, particularly when it comes to education, religion, and medical issues, medicine. So that's the parenting plan. And then child support. Does one parent need to pay the other parent some money to help financially support the children? And we have that when one parent has the children substantially more time than the other parent. So one parent is bearing more of the costs of housing, utilities, hot water, shampoo, food, space for beds, that type of thing, gas, getting them to school, getting them home from school and activities. So gas for the car. Or if the parents split time exactly 50-50, if one parent makes substantially more than the other parent, then the court doesn't want the children to have a particular lifestyle with parent A, where they have clay tennis courts in the backyard and a Olympic-sized pool and a butler, right, and a Ferrari. And at the other person's house, they're in a studio apartment without their own room, and no car, and just bicycles, and a crummy school district. And so the court is trying to get the lifestyles a little more even, so that the children, particularly as they get older, so the children don't just want to go to the house that has the pool and have their friends over, rather than the other parent who can't afford that kind of a house and is in a small apartment. So the court wants to sort of equalize that. They can also do that in maintenance, but part of the child support chart, the way it works, is to equalize the standard of living a little bit, if one parent makes substantially more money than the other. The only time we don't have child support is when they have 50-50 custody and they make exactly the same amount of money, and they split all the children's costs 50-50, then we don't have to have a child support number. Other than that, we need a child support number. Then the third area that they need to make decisions in is called maintenance. Does one party need maintenance, or we used to call it alimony? Some states still call it alimony. Does one party need alimony from the other party? Again, when there's a large disparity of income producing ability between one spouse and the other spouse, for the same reasons that we just talked about with the kids, for kids and for people who don't have kids, we're trying to get them a little closer in their lifestyle. So one person isn't living in government subsidized housing and the other person's living in $1 million mansion. So the different ways to get divorced really come down to how and who makes those decisions in those three subject matter areas I just talked about: dividing assets and debts, coming up with a parenting plan and child support, and whether one spouse needs to financially help the other spouse. If so, how much and how long, until they're a little closer in their ability to support themselves financially, close. So one way to do that is the non-contested divorce, where it sounds like everybody wants it. Well, if one person wants to get divorced, really this is true for every state in the United States. If one person wants to get divorced, that divorce is going to happen. Few exceptions to that, but very few exceptions. The question is, how are we going to divide our stuff? How are we going to parent our kids? And financially, how are we going to divide the costs of living? So the spouses can do that by themselves. Sometimes lawyers refer to that as the kitchen table divorce. So the spouses sit at the kitchen table, or I usually suggest they get away from the knife drawer in the kitchen and they go to a public place where everybody's going to kind of be on good behavior. And so they go to Starbucks or something like that, or sit outside at a cafe and talk about those three issue areas: division of assets and debts, parenting, and maintenance, financial support in the future. So with a non-contested divorce, one spouse hires one lawyer and tells that lawyer what they decided in each of those three areas, subject matter areas. And the lawyer writes up a settlement agreement saying, here's how they've divided their assets and debts, their parenting responsibilities, their parenting money, and is there going to be any financial support in the future? The lawyer writes that up in legalese. The one person that hired that one lawyer takes that marital settlement agreement in legalese to their spouse, and the spouse reads over it. They can even have another attorney look at it, not to represent them, but just to read it and give them legal advice on it. Like, yeah, you've gotten all your rights here, or yes, you have made decisions on all the issue areas that you need to make a decision for a judge to sign off on your divorce. So you can have outside counsel or not, but it goes back to that one lawyer, and that lawyer takes it to the judge and shows the signatures of both parties and runs that case through the legal system with just one lawyer. And the judge looks at it to make sure it's equitable in each of those three areas. It's equitable. And if the judge thinks so, then the judge signs off on it, and you're divorced. That is the fastest, cheapest, most simple way to get divorced. The problematic issues around that kind of divorce is when nobody has legal information about what their rights are when it comes to dividing assets and debts, or what their legal rights are as to time with the children, or what their legal rights are as to maintenance. In Missouri, there are 9 things that the court takes into consideration in deciding whether to issue maintenance and how much to issue from one party to the other. And if you don't know those 9 things, then you don't know if you're eligible for maintenance or not. So there's a burden on the parties to get a lot of legal information, and you can get a lot of legal information on the internet. My suggestion is that you go to your state Supreme Court's website that has all the statutes, and look up that information on the Supreme Court website instead of seeing what people wrote about divorce on the internet. You don't want to be following that because it may be New York law and not Missouri law or Illinois law. And it might not be the law anywhere. It may be a misrepresentation of the law by someone who's not a lawyer. So you don't want to base your future on that. But if you get it off of your Supreme Court website, then you know it's correct. It's the law. It wouldn't be on the Supreme Court website. So that's one place you can get the information. When I have someone come in and say they want to do a non-contested divorce, and they're the person that's going to hire the lawyer, then I download all of the statutes from that website, the Supreme Court website. I give that to them in a packet and say, here's two hours worth of legal information. Read it. You can read it for free. You don't have to have a lawyer tell you. You can read it for free, make a copy of it, or give it to your spouse so your spouse can read it, and then go to Starbucks and see if you can come to decisions in those 3 issue areas. If you have questions, you can write them down on a piece of paper. And the one spouse that's hiring me can bring that piece of paper in. I'll write the answers to the questions down. I don't know whose question that is, and I'm not going to lie to my client. So I don't know if that's my client's question or their spouse's question. So I say, you can write it down and I'll write the answer and take it back to your spouse, and your spouse can trust that that's the answer because I wrote it thinking that it's that it's my client's question. I wrote the answer thinking it's my client's question. So that's a non-contested divorce. The length of time that takes really depends upon how long it takes the spouses to come to those agreements in those three different areas. Then once the lawyer drafts all the pleadings to file for divorce, those pleadings need to be served on the other party, but we can arrange that through a private process server. And we can have that happen on a certain day in a certain parking lot or in the backyard of their apartment, or we can have that happen in a very respectful way. You aren't served in the middle of a church service or at a PTA meeting in front of a bunch of people. It's done in private, when it's going to happen. And we tell you what the process server is going to wear so you can spot them. Even have process servers roll it up in a newspaper and hand it, act like they're jogging by the house and hand it to the person and keep jogging. So service of the proceedings can be gotten very, very easily in a planned manner. Then it's filed with the court, and the person who did not file has an opportunity to answer what their spouse filed, or they can just default. They cannot answer and know that they're defaulting to the marital settlement agreement that they came up with, that the lawyer drafted for that one party. One of the myths out there is that a lawyer can represent both spouses, and we call that a non-contested divorce. The lawyer can represent both spouses and talk to both of them, find out what both of them want, and then sit down and write it. That's not true. That's really an unethical thing for a lawyer to do, and you can get disbarred if you do that as a lawyer. Lawyers I have colleagues who find some pretty unusual ways. Well, we don't go into the office, and we stand in the lobby and we talk about it, so it's not really attorney-client privilege. And I haven't seen many bar associations agree with those tactics. So the law says that it's one lawyer representing one person, and they really shouldn't be talking to the other person. They can talk with the other person with questions if that other person represents themselves. It's called pro se, but it still looks suspicious. And that other person can be tricked into thinking that the lawyer has their best interests at heart and not their client's best interest at heart, not just the client's best interest at heart. So that can be kind of confusing. So I want you to know that if you choose the non-contested divorce, you probably have the least amount of fighting. You spend the least amount of money only on one lawyer. And it's definitely the fastest. But one person is really getting individual legal advice, and the other person is not, unless they hire an attorney just to read over the agreement and give them legal advice just on that agreement in sort of in a nutshell, without knowing all of the property, without doing any discovery of any assets that might be hidden or not disclosed. So that's a non-contested divorce. I have done many of those, and I see them working very well for people who haven't been married for very long. They don't have children, so they don't have to come up with a parenting plan and child support and do the child support chart correctly. They aren't financially dependent on their spouse. They each have a job. So with people in any of those categories, a non-contested divorce is a divorce avenue that really should be considered. I have lots of students, graduate students, use that method to get divorced. They have student loans and bicycles and books and a backpack and a Macintosh, and an Apple computer, and phone. That's it. They don't have much. They have more debt than they have assets. So there isn't that much to divide. They aren't financially dependent on each other. There's no children. There are no pieces of real estate that need to be divided there, because that can be more difficult. You have to get things valued, real estate valued, cars valued. There's no long-term assets like retirement assets. Gee, how do you divide that? And you need a special document to divide retirement assets called a qualified domestic relations order, which is a pretty long, couple month drawn out process to do that. You couldn't do that if you're not a lawyer. And so you'd have to, both parties would have to hire a lawyer to be able to do that and be safe in drafting a qualified domestic relations order to divide up retirement or a pension or 401k, IRAs, anything like that. But if you don't have that kind of stuff, then you really don't need a lot of legal advice. And if you feel competent to make your own decisions, you can do that and then have a lawyer draft it for you. So that's a non-contested divorce. Using symbols, I think of that as a circle, like the kitchen table divorce. One person's on one side, the other spouse on the other side, and they sit there, huddle together, and come up with a plan. So that's a non-contested divorce in a nutshell. If they've been married longer, maybe have children, maybe have retirement plans, maybe have uneven salaries, then that might not work, and they may want to hire an attorney to do a mediated divorce. And so an attorney can be a lawyer for one person, or an attorney with special training, mediation training, can be a mediator who doesn't really represent husband against wife and doesn't represent wife against husband. That mediator doesn't help one person over the other person. They don't represent just one person against the other person. That mediator helps the whole family come up with a plan for divorcing, addressing the issues in those three substantive areas that I've already talked about: division of property, parenting, and maintenance in the future. So the benefit of that over the non-contested divorce is that both parties have access to a lawyer for legal advice, and the lawyer has to give accurate, correct legal advice to both parties. And the lawyer can't like one party more than the other party, help one party more than the other party, can't talk to those parties away from each other. The mediator just talks at the mediation sessions, gives legal information to both parties at the same time, so that there's no suspicion that the mediator is on this spouse's side or doesn't like that spouse. The mediator is totally neutral. Mediator doesn't decide anything. The mediator is not an arbitrator who makes decisions for them. The mediator helps explain what decisions the couple needs to make, and helps the couple come up with options in each one of those subject matter areas that I've talked about earlier. And that can be helpful when the spouses don't agree about dividing the house, or don't agree about dividing a pension 50-50, or a 401k, a retirement vehicle 50-50, because one person owned the house before they got married. So they owned the house for 5 years, paid money into the house, put the down payment on the house, made improvements in the house, and then this person came and moved in. And then they lived there 10 years or 15 years. Gee, how do you divide the house equitably? Well, one person put the down payment down and paid the mortgage for 5 years. Should they get more than the other spouse? Well, probably yes. Part of that is their separate property, and part of the house is marital property. So that's a little more difficult to do and understand. at Starbucks without an attorney. So a mediator can explain all of that to both spouses at the same table at the same time, and then lay out the options for the spouses. And the spouses can throw in options too. It's not just the mediator putting options on the table. The point is to look at all the possibilities of how to divide this house in a way that seems fair to both spouses and is going to pass the muster of the test of the judge looking at it to make sure it's equitable, and come to an agreement. The whole point is to come to an agreement, and the mediator is there to facilitate that agreement, not tell them what to do, or here's what's going to happen in court, or you're never going to get that in court, or to pressure them, look, your spouse is going to get everything in court. That's not the mediator's role. The mediator's, even though the mediator might think that, the mediator's role is to stay neutral and give them information and help them powwow into an agreement that they can live with. People, statistics, lots of studies of mediated divorces versus litigated divorces show that people follow what they promised to do in the mediated divorce, in the marital settlement agreement when they mediated their divorce, because they had a say in it. They had a say in deciding, well, how much of that house belongs to the spouse who bought it, and how much of that house is marital. Once the other person came in and lived in the house and they were married, they put on a deck and they built a pool, and they put a lot of sweat equity and a lot of their money into the house. One person shouldn't just get the house because they lived there first. The house has grown a lot in equity because of the second spouse's contributions, and those contributions should be rewarded and recognized by the court. So that's just one example of where having someone with legal information in the room when the two spouses are making decisions can be very helpful. The other thing the mediator does is help prevent conflict. Preventing the couple from fighting over every little thing that they could possibly fight about. One thing I do as a mediator is help the couple stay focused on the task at hand. What are we trying to do today? Are we trying to come up with a child support chart? Are we trying to come up with a parenting plan? Well, let's just talk about parenting and not talk about, well, this is what happened on 4th of July, and here's what I put into the house, and here's how much I've saved in retirement. No. We're just talking about parenting. How are we going to give the children access to both of you so that the children grow up with a mom and they grow up with a dad, or two moms or two dads? They grow up with the authority figures that have been in their lives all this time, and they have access to those people, so that the children experience the least amount of loss during the divorce. And the mediation is very good at that. Mediation really helps decrease the amount of conflict spouses have in getting divorced. Tons of studies that prove that nationwide. And that's the best thing that they can do for their children, is not fight, because when the parents fight, children think it's their fault, and they feel like they have to pick one parent to back, and the other parent they're going to shy away from. If I'm going to support mom, then I can't be very supportive of dad, or mom's going to think I like dad more than mom, and vice versa. So in a child's concrete brain, it's hard to realize that they have their own relationship with mom and have their own relationship with dad, and mom and dad don't really have anything to say about it. I'm going to have whatever relationship the child, I'm going to have whatever relationship I want with mom, whatever relationship I want with dad, and they shouldn't have anything to say about it. I mean, an adult can do that. It's even difficult for adults, but an adult can do that, but it's very difficult for a child to do that. And they're just trying to get mom and dad to stop fighting all the time. And they think mom and dad are fighting because they did something, and that's really not what mom and dad are fighting about. It's very damaging to the child's self-esteem in growing up and thinking that they caused this marriage, they caused this loss, and it's because they're not good enough, they aren't lovable, they aren't heard. They aren't heard. So mediation can help a lot with that. Then when the couple has come up with an agreement in each one of those three categories, the mediator writes it down in legalese. If the mediator's an attorney, they can write it down in legalese. Therapists can also be mediators if they're trained in mediation, and they can't write it down in legalese because they're not licensed attorneys in that state, but they can write what's called a memo of understanding. And so they just take the legalese out and say, this person takes the black car and this person takes the green car. Then attorneys turn that into about a page and a half of legalese with the VIN number and the car description and how much the car is worth, how much is owed on the car, whose name the car is in, and where the car is registered, and who's going to take the car, and how they're going to get the other person's name off the car. And that takes a lot of space to write. That takes a lot of paper to write. Whereas if it's a therapist mediator, they just write who's taking which car. And then they hand it over to an attorney who writes it out in legalese. They don't change it. They just put in all the legal information that the judge needs to make it an appropriate, proper legal agreement that's enforceable by the court system. So when I think of a shape for mediation, I think of a triangle, a mediator at the top of the apex of the triangle, and then spouse A here and spouse B. So we're making like a triangle. And I try and do it when I mediate, I try and do it at a round table. And the three of us sit equidistant around the round table. Nobody's at the head of the table. Nobody's in charge. The mediator's in charge, but nobody's the decider. Nobody's the judge. And the mediator helps the couple come up with an agreement that they can live with and that they have planned themselves. And then they're much more likely to follow that with much less conflict. So that's what a mediated divorce is. Then the last category is a contested divorce. Again, makes you think somebody's contesting it. Well, they both might want a divorce, but we call it a contested divorce if the parties have not come up with an agreement in each one of those three subject matter categories before they divorce. So before they file for divorce. So if they don't have an agreement already set out, written by a lawyer, when they file for divorce, then that's a contested divorce. Many contested divorces become uncontested before they get to the point of a trial. So when a contested divorce is when spouse A hires an attorney, spouse B hires an attorney, and those two attorneys represent just the best interests of their client. They aren't there for a kind of a holistic, how can we keep this family together and keep the kids involved and give the parents equal time or give the children equal time with the parents. It's more of an adversarial role that the lawyer takes in a contested divorce. So the lawyer is an adversary against the other lawyer in favor of their client. That can kind of get out of control and become a fight between the two attorneys, as well as between the two spouses fighting. I mean, the attorneys can kind of fuel that fight, or the attorneys can fight because they're being mean to each other and not respectful to each other. That happens a lot. And then that takes on a life of its own, and takes much longer to resolve, has much more conflict than the parties had at the very beginning, and costs a lot more money because you're paying lawyers to fight for you, and those lawyers are fighting anyway. So they're kind of on a fighting rampage, and it's and they're also trying to settle the case. So in most states, they have a certain amount of time to try and settle that case, and they get access to a judge to ask a judge, well, do you think this is a maintenance case? Here's how much each party makes, or what do you think about the parenting here? This parent travels out of town a lot. So they can get some guidance from the judge that's in charge of that case, and take it back to their clients. But if the clients can't agree, i.e. their attorneys don't agree also, then that case goes to trial, and a judge hears evidence from spouse A and spouse B through their attorneys. They take the stand, they testify against each other. Anybody can come to the trial that wants to, unless it involves children and or adolescents, and then they have some privacy rights there. But that's the kind of trials you see on TV, because they're the most interesting, and that's a contested divorce. And then a judge makes the decisions in each of those three areas and writes out their decision. It's called a judgment, and they don't tell the people at the time, because they have some pretty hot-headed people in that courtroom, and they don't want to say you win, you lose, because bullets might fly or chairs might fly, and tempers are pretty high. So the judge can take a long time. A judge can take 24 hours or several months to make a decision as to what each party gets and what they don't get, what they have to pay, and what goes to whom, and writes it out in a multiple page judgment, 5 pages to 10 pages judgment, mails it to the lawyers. The lawyers give that information or mail a copy to their clients. And that's when the divorce is done. When the judge makes the decision, writes it out on paper, sends it to the lawyers, then that case is finalized. The parties do have the ability, if the judge made a mistake, the judge made a mistake, the judge didn't follow the law, there's some kind of error committed during that trial, either the parties can appeal that case to an appellate court. That's another $20,000-$30,000 and a year to 2 years to get through the appellate system, depending on what state you're in. Just trying to give you a feeling for the cost of that and the length of time of that appeal. And the appellate court will either affirm what the trial judge said, or say, no, they made a mistake and we think it should be this way, or yeah, that judge made a mistake, we're going to correct the judge and send it back and have the judge. That can add even more time and more cost to the divorce, and more conflict. It's just a lot of years of conflict there. It kind of becomes a Hatfields and McCoys. So in a nutshell, those are the three most common ways to get divorced. If you have any questions that you would like to ask, or if you have any ideas of what you would like me to share with you during one of these broadcasts, feel free to leave notes in the comments on the Facebook page that we're streaming this from, and we'll take a look at that. If we can answer those questions, we will. And if we can have a broadcast on a subject matter area that you would like me to cover with you, we'll be happy to do that. We'll try to do that. So thank you so much for listening. Thank you for your support, and Godspeed.